Okay. Now we listen to you, Mr. Canavas. The floor is yours, please. Thank you.
Thank you, Your Honor. And good morning again to everyone in and around the courtroom. The facts are what they are. You have them before you. You be the judge of it, no pun intended. The OTP in its closing brief brazenly entreats you to inappropriately draw negative inferences against Mr. Gicheru and to unjustifiably relieve it of its burden of proof. Having relied almost exclusively on the testimony of grifters, opportunists, skilled storytellers, and documented liars, and with the defense having exposed the abundance of reasonable doubt on every count in the case, the OTP now is faced with an acute dilemma: how to dress up its witnesses, how to rehabilitate them, how to transform them into honest, truthful, disinterested witnesses, how to manipulate their testimony, how to overlook their major, not minor as they characterize, inconsistencies and overall flaws, how to ignore their discredited testimony, or shall I put it, how to make a silk purse from a sow's ear. Motivated by raw, unconstrained desire to win and corrupted by tunnel vision, evident from the way the investigation was conducted. And here, we never complained about not bringing those witnesses, but why didn't they investigate those they claim are part of this grand scheme? The OTP bought into and latched onto lies, fairy tales, fantastical excuses, and rationalizations, all while ignoring obvious flaws and contradictions, and weaponizing the verb to clarify into means of confabulation and memory development. If you didn't get the facts right the first time or the second time, if you didn't tell us the truth, just try again and again and again. We'll just call them minor inconsistencies. And your countless attempts to get it right, as we heard, clarifications. Just keep clarifying. Realizing that it cannot withstand the scrutiny demanded by the statutory provisions of the rules of procedure and evidence of the ICC, the OTP now advocates for you, Madam President, to put your thumb on the scales of justice, to tilt them in favor by overlooking the weaknesses and gaps in its case, by casually assessing the evidence, by accepting its testimony on whose voice it is on the tape-recorded conversation, and to adopt its interpretation of what was said in another telephone conversation by one of its witnesses who was scripted by the OTP investigators, but unfortunately was unavailable to be confronted, examined, and impeached by the defense. The OTP, in its brief, argues that it was disadvantaged and that we took advantage of them by tailoring our case to its evidence by stonewalling them, not agreeing to its proposed agreed facts, not divulging the theory of the defense, not giving an opening statement, and not putting our case to the witnesses. They argue that you should view the evidence through its result determinative prism, that you assess the evidence by ignoring critical nuances in the ICC jurisprudence, which I'll point out, that you overlook the lack of quality in its investigation. Yes, they are expected to go and investigate. That you fill in and bridge over the gaping gaps in their case, that you excuse the lack of certainty and ignore the reasonable doubt that persists in this case. And, might I add, that you haphazardly find that it has met its burden of proof. Now let me talk a little bit about this notion that we tailored the defense. They argue that we tailored our defense by stonewalling. I've never seen this before in a brief, I must confess. This is in paragraph 63 and 309 of their brief. This argument is embarrassingly amateurish, and it's, as it is, how should I put it, absurdly vacuous. Firstly, it is undisputably obvious that we, the defense, relied exclusively on the disclosed material that we got from the OTP. There were no tricks, there were no surprises, there was no new evidence. Just what was in their possession for years and years, except the newly evidence that they came up with that was disclosed to us through this clarifying and memory development interviews and proofing sessions, which we discussed during the trial. Secondly, about tailoring. Here, with apologies, I might have to give a short lecture to the prosecution on the art of trial advocacy. A trial, by its very nature, is an organic process. It's dynamic, it's not static. And it's a cardinal rule that you show up prepared, but you remain flexible. You remain in the moment. And to do otherwise could amount to ineffective assistance of counsel. When circumstances change, you should adopt. But once the theory is chosen, the trial begins with that theory. Strategies and tactics may alter, but the theory remains. And we'll talk about our theory too. Thirdly, where in the statutory provisions, the rules, the regulations, the practice directives, or jurisprudence, does it prohibit the defense from recalibrating or tailoring its defense during the proceedings? I've searched. I haven't been able to find any authority. I'm unaware of any authority. This is the very first I've ever heard of this. Finally, so what? So what? How did this supposed tailoring we engage in compromise the OTP in presenting its case or negatively impact its burden of proof obligation? How? Rather than own up to the inconvenient details of its evidence and to make a go at arguing at the evidence and to show that they proved their case beyond a reasonable doubt, they opt for excuses, and they opt for what I call the skunk factor. You bring a skunk into the courtroom for a second or two, take him out. The skunk is out, but the stench remains. It's all about insinuation. Simply, the prosecution is attempting to deflect and misdirect, to patch and gloss over its inadequacies and failures, to influence you by insinuating you to draw negative inferences. In other words, to compensate and assist it in meeting its burden of proof. They say we did not agree to their proposed agreed facts. Where in the statute and the rules of the jurisprudence says that the defense must agree to their proposed agreed facts? And so what? Again, how did this unwillingness or inability on our behalf compromise the OTP in presenting its case or negatively impacting its burden of proof obligation? They argue we did not disclose in advance the basis of our defense. My goodness. I'm hearing this from professional prosecutors at an international tribunal. Where in the statute, the rules, the jurisprudence, does it say that the defense must explain its case to the OTP in advance. Where? But it gets better. But in any event, should I have telegraphed or emailed or sent them a WhatsApp message to tell them, hey, here are the weaknesses in your case. Please shore them up by doing a little clarifying and memory development when you question the witnesses and you proof them. Can the OTP seriously, truthfully, claim that they were in the dark when you consider our submissions to the document containing the charges, our numerous requests for disclosure material, the general nature of the statements of the witnesses that they chose to bring to this court? Can they seriously say a newly minted lawyer with, I submit, a basic trial advocacy course of a few days under his or her belt could figure out the defense? But it gets better. I submit that the prosecution, especially the senior trial lawyer in this case, is being economical with the truth when he claims that we did not explain our theory of the case. You may recall during the cross-examination of P0613, in response to an intervention, I laid out the theory, the thesis as I called it at the time. And later on, and this is in the transcript 058, page 14, the prosecutor, Mr. Steinberg, stands up and says, quote, "I am always grateful when we actually have some notice as to what the defense theory is." Now granted, it was only the second witness. So we had been in the case for a matter of 2 or 3 days. But can he seriously say that we didn't know, that we didn't disclose our theory? But again, so what? So what if we did not indulge them by providing them in advance what the theory was? Although I say that even Stevie Wonder, the great American blind, singer, could see what the defense was. How did this failure on our part compromise the OTP in presenting its case or negatively impact its burden of proof? They go on and they complain, we did not give an opening statement. Goodness gracious. We did not give an opening statement. Where in the statute does it say that the defense must give an opening statement? It doesn't. And not to mention an opening statement is not evidence. And so what? How did this strategic or tactical decision on the part of the defense compromise the OTP in presenting its case or negatively impact its burden of proof obligation? Frankly, if I were a prosecutor, or in this case, the deputy prosecutor of the ICC, I would be embarrassed to argue this, no less put it in writing for God and mankind to see it in perpetuity, that the prosecution was disadvantaged, or that the defense gained an advantage by not giving an opening statement. They claim we did not put on a case in detail. We did not put our case in detail to each of the OTP witnesses. There's no statutory provision or rule in the ICC requiring the defense to put its case in detail to each witness. Now, there is a provision in the ICTY, and in the Ruto and Sang case, there was a practice directive that suggested that it would be a good idea to put your case to the witness so that the witness would not be confused. But there's no obligation. Interestingly, they cite the very famous Brown and Dunn case. It's an Australian case, as I understand it. In the United States, we don't have this notion of putting the case to the witness, nor do we even use the phrase, "I put to you," though I used it because we are in this international settings and this seems to be the norm. But in citing Brown and Dunn, and in citing ICTY Rule 90H small I, double I, the prosecution would have noticed the appeal decision in the Kreisnick case, where it says, it is sufficient that the cross-examining party put the nature of its case to the witnesses, meaning the general substance of its case, conflicting with the evidence of a witness, chiefly to promote this witness against any confusion. They go on to say there is, quote, no need for the cross-examining party to explain every detail of the contradictory evidence. They go on even further. It is obvious in the circumstances of the case that the version of the witness is being challenged, that if that is the case, there is no need for the cross-examining party to waste time putting its case to the witness. And that's in the appeal judgment, paragraph 368. In any event, this claim, like many of its other claims, is a canard. Anyone watching and listening to the cross-examination of the witnesses could tell, would have noticed that Mr. Manovich and I robustly put our case to the witness. But even if we fail to do that, as they claim, so what? How did this failure compromise the OTP in presenting its case or negatively impact its burden of proof obligation? We submit that the OTP is misdirecting you to view the evidence through a distorted, result-determinative prism. The OTP argues that you not assess the evidence of each witness separately. At least that's our reading of their brief. We disagree. The ICC jurisprudence from Bemba et al. Informs us of a more nuanced approach than that which is claimed by the prosecutor. The Bemba et al. Trial chamber held that, quote, each statement made by a witness must be assessed individually. Each statement made by a witness must be assessed individually. Now, this is the trial chamber, mind you, and it's in paragraph 202. But finding no error of this approach, the appeals chamber noted in paragraphs 1019, this is Bemba et al., whether a particular witness is considered credible will depend on a case-by-case assessment of the evidence in light of all relevant circumstances. Given the nature, we submit, of the testimony of the witnesses, the extent of their impeachment, their numerous statements, their clarifications, their half-truths, their lies, their inconsistencies, the uncorroborated hearsay, we submit that, with respect, that you must assess each statement made by the witnesses individually. The OTP argues that you holistically analyze each individual item of evidence in light of the entire body of evidence, even if, when viewed in isolation, they're open to different interpretations. That's paragraph 11 and 13 of their brief. We disagree. This approach to analyzing the evidence holistically, as they claim it, is not consistent with ICC jurisprudence, nor is it a sound approach in this particular case in light of the testimony of the witnesses. The appeal chamber in Bagbo and the separate opinion of Judges Van der Weingart and Morrison in the Bemba appeal judgment are instructive, and we submit should give sufficient guidance to you in assessing the evidence. But what does a holistic evaluation of the evidence mean? Well, it means that the weight accorded to individual witnesses' evidence should be determined in conjunction with other relevant evidence. Bagbo appeal judgment, paragraph 67, and that separate opinion I noted in paragraph 15 in the Bemba et al. So, in holistically evaluating the witness's testimony, what must be considered? Here we submit that the Nitaganda trial judgment, paragraph 78, provides some guidance. You must look to the entirety of the witness's testimony, the witness's consistency and precision in accounts, whether the information provided was plausible, the witness's conduct during their testimony, their demeanor, contradictions with prior recorded testimony, and how that witness's testimony relates to the testimony of other witnesses. But here I would add one more. I would add the days and the hours spent during the so-called proofing sessions. Now, Judge Van der Weingart and Morrison further explain on paragraph 15 of their separate opinion in Bemba that holistic fact-finding cannot, and I quote, cannot be an excuse or a reason for making findings beyond a reasonable doubt on the basis of a collection of weak evidence. And, they go on to say, it cannot cure the weaknesses of individual items of evidence. Cannot be an excuse or a reason for making findings beyond a reasonable doubt on the basis of a collection of weak evidence, which we submit you have before you, and it cannot cure the weaknesses of individual items of evidence. The OTP argues that you may rely on one part of a witness's testimony while rejecting others, since no witness is per se unreliable. Well, you know, even the clock is right twice a broken clock is correct twice a day. Fair enough. No witness is per se unreliable. But again, the jurisprudence of the ICC is somewhat more nuanced. In Gunjolo, I apologize for my pronunciation of the names, informs us that, and this is in the appeal judgment, paragraph 168, that some witnesses may be impeached to such a degree that they, quote, cannot be relied on even if other evidence appears to corroborate part of his or her testimony. They go on to say, witnesses whose credibility is impeached, quote, may be relied on to the extent that they are corroborated by other reliable evidence. This is the jurisprudence, and all we ask is that you follow it. The OTP argues that you need not consider evidence tainted or unreliable due to what they call minor inconsistencies. That's in paragraph 28. Well, if there were minor inconsistencies, I can assure you, Your Honor, we certainly didn't waste our time during our cross-examination of those witnesses. We went after the big-ticket items. With the exception of two of their witnesses, all the other witnesses who appeared in court were impeached to such an extent, and their evidence was shown to be so full of major inconsistencies on core aspects of their testimony that they are, we submit, incapable of belief. They lied under oath, with the determined reason and purpose. And here, let me just go off script and say I'm offended by my colleagues, my learned colleagues' suggestion that I somehow was suggesting that all Africans want to leave for Europe. That was not the claim. The witnesses that he paraded before you, those were the ones that we demonstrated had a plan and wanted to get out. And we demonstrated that. And we, in fact, brought one witness, they brought one witness who gave good evidence on how he and two other witnesses plotted how to lie to the prosecution, knowing that the investigators were not going into the field. And to that they say, so what? We say, so plenty. The OTP claims that the chamber should distinguish the actions and statements made while the witness were under the corrupt influence of the perpetrators, and the statements when the influence was removed. And this is in paragraph 35. Well, first of all, they provide no legal authority as to that's how you should parcel the assessment process. Well, how do you determine when they were under influence, at what point, and when supposedly this influence was lifted without doing a complete evaluation of the witness's testimony, without analyzing that in conjunction with everything else, as I'll talk about in a bit. The OTP is asking you, Your Honor, to ignore weaknesses, inadequacies, contradictions, documented lies, and uncorroborated hearsay to support their position. And they're asking you to essentially cherry pick, to simply adopt the most recent one, the most recent version of the many, many events. We had one witness, he was questioned 50-some times. Just adopt the very, very last one, because by that point, the clarification and memory development had been solidly put in place. Normally, I wouldn't do this, but in an international court, but I think it would be instructive considering the nature of the evidence that we heard and the arguments that are being made by the prosecution. I'm going to give an example. I should tell this to my juries, but I think it's apropos for judges as well. And it's my beef stew example. Suppose you go to a restaurant and you order beef stew. That's your favorite meal. You've been looking forward to it. Maybe you've been to that restaurant before. That beef stew looks good. Right texture, right color, the scent, unbelievable. Take a spoonful. My goodness, it's tasty. Take a second one, then you bite into a piece of meat. First piece is good. Second one is also good. Tender, moist. Third one, you realize is rotten, is bad. Now, what are you to do? You're supposed to sift through your beef stew to figure out which piece of meat is good, if any of them now, because all of them have been contaminated by the bad meat. Or should you say, you know what, I'm going to put this dish aside, maybe I'll order something different, or better yet, I'll go to another restaurant. That's what they're asking you to do, Your Honor. They're asking you to sift through and try to cherry pick and decide what pieces of evidence a witness gave might be, after being impeached all over the place, might be good enough for you to latch on in order to find reasonable, that they prove their case beyond a reasonable doubt. We submit that the witnesses were so corrupted in their own contradictions that you cannot easily find what is good and what is bad, like that beef stew. Better set it aside. The OTP is misleading you into misapplying ICC jurisprudence on corroboration. Normally I wouldn't lecture, I wouldn't dare lecture a court on what the law is, but, and nor am I trying to lecture, but merely offer some, my perspective on what I believe, or we believe, the law is on corroboration before the IC, based on the IC jurisprudence. And of course, the prosecution made a big deal about this, about corroboration. And they argue that corroboration is not required, that it is merely an occasional important factor. That's paragraph 32 of their brief. Not required, just an occasional important factor. Well, in this case, I submit corroboration on all those witnesses was indeed an important factor, not an occasional one. And they are economical, again, with the interpretation of settled ICC jurisprudence. Here, I would submit we look at the appeal chamber in Bemba et al., paragraphs 1084, Bagbo, appeal judgment, paragraph 357. They inform corroboration may be required may be required to be convinced of the credibility of a witness and reliability of the witness's testimony. The appeals chamber in Gicheru, paragraph 168, as well as in Bemba et al., trial judgment 204, further informs that where the trial chamber has reservations about the credibility of a witness, has reservations of the credibility of the witness, it may rely on his or her evidence, quote, to the extent that it is corroborated by other reliable evidence, noting that some witnesses may be, quote, impugned to such a degree that they cannot be relied upon, even, I underscore that, if other evidence appears to corroborate. They cite ICTR case law. They argue that by citing that witness corroborate each other when, quote, one prima facie credible testimony is compatible with another prima facie credible testimony regarding the same fact or a sequence of facts, paragraph 33, footnote 64. So that's what they say. Now, surprisingly, I went and looked at that. This fine defense team, surprisingly, the OTP cites authority that has been rejected by the ICC appeals chamber. Now, I'm going to give them the benefit of the doubt. I certainly don't think that they're trying to deliberately misrepresent, to take an advantage, but merely it's just sort of the endemic sloppiness that we've seen throughout the trial, and it's their failure of diligence at times. The Bagbo Appeal Chamber summarily rejected the string of ICTY case law cited by the prosecution for the very same proposition, finding that, quote, there is need for great care in describing the parameters of corroboration in terms so broad and uncertain, paragraph 358 of the Bagbo Appeal Judgment. They go on to say that they did not consider that the ICTR's description of corroboration, quote, means without more than two pieces of evidence corroborate each other merely by bearing a relationship to the same fact. A relationship. So that when we talk about compatibility, that's what they're talking about. Paragraph 358 of that particular appeal judgment, that may be of use. They argue that witnesses corroborate each other because their testimony is, quote unquote, thematically consistent. It's thematically consistent. They have a theme. I'm going to talk about that in a bit as well. But this is an absurdity we submit. First of all, they cite no legal authority. Zero. Where does it say in the jurisprudence? Well, in their brief, they don't cite anything. Where thematically consistent is good enough, that means corroboration. Judge Henderson, who prior to coming to the ICC had a distinguished career, very distinguished career as a career prosecutor. So he wasn't one of these liberal defense lawyers. You know, he's a career prosecutor. In the Bagbo trial judgment, explained why the hearsay statements made by unreliable witnesses cannot mutually corroborate each other. And here's what he says. Now, this is former career prosecutor, now judge. Corroboration only occurs when two pieces of evidence independently confirm the same fact, quote unquote. And, he goes on, quote, requires the respective items of evidence to have some intrinsic probative value in their own right, end of quote. And he illustrates, quote, if two items of evidence assert the same fact based on anonymous hearsay, the combined evidentiary weight remains negligible, even if there are grounds to believe that the respective anonymous sources are independent of each other. And you can find that in the trial judgment of his reasons, paragraphs 47 and 49. In rejecting the ICTR case law on corroboration cited by the OTP, Bagbo appeal judgment, the appeal chamber, paragraph 358, also said, consider that mere consistencies or compatibilities in a witness's testimonies are not sufficient for corroboration, explaining, quote, the mere fact that items of evidence may have a linkage does not, I repeat, does not mean that they are corroborative of one another. This is ICC jurisprudence. So corroboration is not just merely a factor that you occasionally look at, especially when you got witnesses that have been extensively impeached. And we submit that the case law that we provide provides ample guidance to you, Your Honor. Now, the OTP is misdirecting you to speculate. I'm not going to go into too much of this, but just hit some highlights, and I'll try to go rather quickly. Whether the defense questioned all the witnesses, because they make a big deal of it. One witness was not questioned. Therefore, what that witness said, that's proof beyond a reasonable doubt. No, I'm sorry. That's not how it works. Whether we question a witness or not is irrelevant. And it's irrelevant because they have the burden of proof. We decide whether we're going to question somebody or not. Now, on that particular witness, which we didn't question, what could that witness have offered? Never met Mr. Gicheru? Never knew Mr. Gicheru? Never heard Mr. Gicheru? That the prosecutor speculates, testifies essentially, it was Mr. Gicheru on the line. Whether the defense dispute the reliability of the phone data or process of extraction is irrelevant. We're not saying that these experts weren't experts, but what does that data tell us? It doesn't tell us anything. The prosecutor today testified a little bit, telling us what inferences you should draw. Well, that's not in the reports. They can't tell us when those numbers were actually in at the time. Whether the defense dispute the authenticity or reliability of the bank records is irrelevant. You can bring all sorts of bank statements. That doesn't solve the issue. Where did that money come from? We provided some alternative plausible explanations. There may be more. He says, well, 25 dependents, that's how it normally works. Well, what he omits to say is that that gentleman wanted him and his 25 dependents to be taken to Canada. That's what that was all about. As for the other gentleman, we know that when he left his house, as it was being burnt, the one thing that he took with him were the land titles. Did the prosecution ever investigate what he had to see whether any sales were made? Did they investigate? No. They say, well, the defense should come in and investigate. That's not my job. That's not my job. My job is not to solve. and I'll talk about that. His job is to prove whether the defense disputed expert evidence on enhancement of audio recordings. That's irrelevant. What's relevant is the veracity of what is being said and the ability to test that, to test what is on that. Whether the defense disproved what was said by witnesses in audio recordings, the same thing. Whether the defense disproved what was said by P0397 in that scripted conversation. Well, you have Mr. Gicheru's statement. And he does give an explanation. Now they make a big deal to say, well, you know, he denied knowing him. Well, if one person is missing and is well known, and another one is dead, and that's well known, someone being questioned as a suspect and being asked about those two individuals might be hesitant. Here again, I normally wouldn't say this in front of an international judge, but I'll use one of my examples that I would in front of a jury. Mr. Gicheru is only human. Now, St. Peter denied Christ 3 times, and he was told in advance, you're going to deny me. He said, no, don't worry about me. I'm solid. I'm there. I'm with you. He denied Christ 3 times. Now, that was St. Peter. Are we going to hold Mr. Gicheru to a higher standard? Is it not possible that under stress, under fear of maybe being implicated in the disappearance and murder of 2 individuals, that the natural reaction would be, no, I don't know these people. But then he did discuss his involvement. As far as what was said on the tape-recorded conversation, there are a number of reasons why somebody might not answer or might not interject, especially when it's obvious from listening to the conversation that the one side of that conversation is trying to engage and trying to inject information into the conversation because that's what was scripted for him. But, Your Honor, you have that evidence. You don't need a lecture from me on how to evaluate it. I'm almost there. I'm almost over. Get to my final remarks. The OTP argues, and I quote, where the prosecution has produced evidence that establishes proof beyond a reasonable doubt, unless the defense is able to present controverting evidence sufficient to raise reasonable doubt, the accused must be convicted. That's in paragraph 18. So, they produce their evidence unless we rebut it, you know. Well, they either misapprehend how evidence should be assessed, or they simply attempt to mislead. Either way, they're wrong. Whether the OTP has produced evidence establishing proof beyond a reasonable doubt is a question that can only be answered after, and only after, all of the relevant evidence is assessed. This includes the evidence adduced by the defense. They claim we didn't put on a defense. Well, we did. We put on a defense through cross-examination, and everything that came in through cross-examination is evidence. So it's not, well, we put the witness on direct. What the witness said on direct is proof beyond a reasonable doubt. If the defense didn't contradict it, it stands. It doesn't work that way. It matters not whether the defense opted to put on a defense by calling witnesses or not. Our witnesses, our evidence came in through the cross-examination. And we submit that in assessing the evidence of each witness, you also have to, and whether that evidence was presented to a level of proof beyond a reasonable doubt, it is necessary, I would normally say it may be necessary, but in this case I would say it is necessary for these particular witnesses to consider the assessed evidence of other witnesses and any other assessed relevant documentary evidence. So contrary to the accusations lodged by my learned colleague that we somehow want you to piecemeal it, no, that's not the case. But you have to start somewhere. And you don't start with a global picture. You start by looking at each statement individually, each witness individually. Then you look at the other evidence and how each witness is connected, and all of them were connected in one way or another, and we demonstrated that. And only through that process will you be able to find where the truth may lie. Or better yet, or I should say more importantly, whether the prosecution has proved its case beyond a reasonable doubt. So, contrary to what my learned colleague is suggesting, and maybe I got it wrong, but they seem to be suggesting that this is some sort of a competition between two competing narratives. And you are to decide which is the more attractive, persuasive, compatible, thematically agreeable, or possible, or even plausible. Well, and I submit it is not. It is not about selecting two competing narratives. They have a burden. They have to prove their case. I don't have to put on a narrative. But I can poke holes at their case. I can show that they have reasonable doubt. I can show that their witnesses are inconsistent, that they have among themselves planned and colluded. And it's not about weighing probabilities. Which of the two versions is more, probable? It's not about that. It's not about beliefs, feelings, intuitions, or suppositions. It is not about opinions formed through the media, from having been exposed to information during the confirmation process, or even during the presentation of the evidence during the trial. Now, let's be honest. We're all human. We are influenced to one degree or another by what we hear and what we may be exposed of. And there's nothing unusual or wrong with that. We're going to form opinions, beliefs, hunches. But, and this is the big but when it comes to assessing the evidence at the end of the trial, these opinions, beliefs, feelings, hunches, and suppositions must be set aside. Not only that, but we submit that you must guard vigilantly and uncompromisingly from assessing the evidence through a prism of those opinions, beliefs, suppositions. And there lies the danger, we submit. Far too often, we form an opinion, and then we begin to look at the evidence and the facts, but we're looking at it through the prism of that opinion that we've already formed. And that can be misleading. That can mislead us to the wrong assessment. And we say that has to be set aside. So what we're asking you, Your Honor, we're asking you that you objectively assess the evidence, as we know you will, without passion or prejudice, by strictly adhering to and remaining within the contours of the ICC jurisprudence. And any opinions that might have been formed as a human being while the testimony was being heard, set that aside. Look at the evidence objectively, all of it, holistically, as the prosecutor wants you to, but in the manner in which we say must be. Now, let me conclude with a few words of the burden of proof beyond and the burden beyond a reasonable doubt. Again, normally I wouldn't do this in front of a judge, but I feel compelled that that in this instance, this is one of those rare occasions in an international court in front of a professional judge that I might be of some use, especially when you take up the task, which only you can do, this heavy burden of assessing all of the evidence and determining Mr. Gicheru's destiny. So I think that the definition of proof beyond a reasonable doubt from my own national jurisdiction, this is Alaska, is a rather good one, and it's consistent with more or less the definitions used throughout the United States. And it's proof of such a convincing nature that you are willing to rely and act upon it without hesitation in your most important affairs. Rely and act on it without hesitation in your most important affairs. Now, trying to explain that to a jury sometimes is pretty difficult. So, the way I would do it is maybe by way of example. And in this particular case, I try to think, what example might I give, Your Honor, to sort of assist you as you and your staff are looking at the evidence, to have in the back of your mind as you assess the evidence. Well, let's just say, and this is not one of the most important affairs, buying a used car. Maybe buying a new car or buying a house or getting married, that's an important affair. But let's just say just a used car. Now, you're like me. You don't know too much about engines. So you're going to bring somebody along with you who knows a little bit, who's going to be able to ask some questions of the used car salesman, because at least in the United States, I don't know how it is anywhere else, but at least in the United States, used car salesmen are slick talkers, and half the time, or most of the time, they're sort of embellishing on the facts. So you bring this fellow along to help you out, buy this used car. You see the car, it looks shiny, it's been washed, wheels look good, rims are shiny. You pop up the hood or the bonnet, as the Brits say, and you see this clean engine. So, and you hear this gentleman say, well, this is a new engine. And he's talking and talking. And then all of a sudden your friend starts asking some questions. And as he's asking questions, he's catching this car salesman in little lies, and then more lies, and then contradictions. And after each contradiction or lie, there's a clarification. Well, what I actually meant to say was this. And this goes on for some while. Question is, you want a used car so you can take you and your family, your loved ones, your friends from point A to point B, go on the highway and be safe. If in that circumstance, where the used car salesman is telling you all these inconsistencies and lies and is unable to keep his story straight, would you, without hesitation, buy that car from that salesman? I dare say no. But let's just say, lo and behold, as this is going on, somebody else shows up. And he knows the used car salesman. Maybe he's also a used car salesman. And he starts chiming in and echoing the same things that the first one is saying. Oh, yes, this is a new engine. Of course, your friend is pretty savvy. So he starts asking questions of this fellow. And sure enough, the lies keep coming, the inconsistencies, the contradictions. And all of a sudden, another one comes. And the same thing goes on for about 6 to 8 witnesses. One of these fellas. Would you buy that used car? Because now you've had 8 people or 5 people or 6 people or 3 people come and say, this is a new car, a new engine in this used car, believe what we're telling you, would you be comfortable? Would you, without hesitation, would you be certain? Because that's what proof beyond a reasonable doubt means, certainty. Would you be certain that this is the car that I must buy without hesitation and put my life and the life of my loved ones in the hands of this particular car? I dare say no. And that's how the prosecution's case is. And we submit, Your Honor, that in assessing the evidence, keep this in mind. Because you should only find proof beyond a reasonable doubt if you are certain. We submit that in this particular case, the OTP has failed to meet its burden of proof. The only appropriate, fair, and just verdict is a not guilty verdict on all counts. Now, I notice I have a couple of minutes left, so I just want to thank everyone who made this trial possible, starting with the stenographers, the interpreters, the IT folks, the guards, the legal officers for the registry, your legal officers, and of course you. With all due candor, I can say that this is one of the best tried cases I've had in my career. And it's a testament to everybody involved in this process, but especially you for presiding over what I would call a very efficient, a fair, balanced proceeding. I want to thank the prosecutor. As cases go, this was not very contentious. In fact, I was almost comatose most of the time compared to some of the other cases that I've been involved with. And it's a testament to Mr. Steinberg and his staff. They have been professional, and we appreciate their hard work. And we know that they have a job to do. We disagree fundamentally with what they claim, but nonetheless, we appreciate and we respect their efforts. Lastly, I want to thank and give credit, basically, to give credit to Mr. Manovich, Mr. Almat, Ms. Machete, and Ms. Aman Lanier. Without them, the defense would have faltered. Any mistakes, of course, that were made, whether they're in the briefs or otherwise, are entirely of my own making. And if during the course of these proceedings, in any way, I may have offended you or anyone else, hold it against me, but not against Mr. Gicheru. Thank you very much.
Thank you. Your Honor, I'm constrained to request leave to respond to one or 2 points. Conscious.
I'm afraid not, Mr. Steinberg. I'm sorry.
All right.
Thank you very much, Mr. Canavas, and thank you very much, Mr. Steinberg. I thank both teams, the prosecution and the defense. This concludes the closing statements. The Chamber wishes to thank also the registry for the support and help throughout this trial, and that would include everyone in and outside of this courtroom. I appreciate the interpreters. I thank you very much. The transcribers and court officers. But I also do greatly appreciate the VWU and many more. I thank my officers, my legal officers, my team of legal officers for support to this trial. I must say it's a trial which I enjoyed very much, so I thank you all very, very much. The Chamber will now retire and retire to do our deliberation as required of us under Article 74 of the Rome Statute. So the hearing is adjourned.
All rise, vojevo leve.